King, and the rest of the members of the committee, good evening. My name is Elsa Alcala. I represent the Texas Defender Service, and I'm here in favor of House Bill 472. I'd like to talk very briefly about three things. First, the distinctions in the law of parties. Secondly, I'd like to point out that the defendant would still be found guilty of an offense of murder. And third, I'll explain why I am in favor of the bill. First, people like to use the term law of parties, but in some ways it's a misnomer because there's actually two different kinds of laws of parties. In Texas, you can be found guilty of an offense in three different ways. You can be the actor yourself who does the bad act. Secondly, you can be guilty under the law of parties in the sense that you solicit, encourage, direct, aid, attempt to aid another person who causes the death. That is what I would call direct law of parties, where you intend capital murder and you either aid, abet, assist, solicit, encourage, or attempt to aid somebody else to commit the offense. All of those two ways are left unchanged under this bill. You can still be found guilty of capital murder and still be sentenced to death under the law of parties where you intend capital murder. All that this bill does is say that you can't be found guilty of capital murder when you didn't intend to cause the death.
So,
That's the conspiracy part of the law of parties.
So under this, if I'm driving a getaway car and somebody runs into a convenience store and it's an armed robbery and they kind of panic and shoot and kill somebody, what would happen to me?
It depends. If you intended to aid, abet, assist, encourage, or attempt to aid the shooter who was inside committing the act and you intended capital murder, you can get sentenced to capital murder and you can be sentenced to death.
And generally that happens, neither one of them intended to kill anybody, it's just that they went in there with a gun and things went wrong, or they panicked, or they were drugged up or whatever, and they shot and killed somebody, and the person got in the car driving. So would that person not get the death penalty for that?
From my understanding of what you're saying, yes. For the conspiracy part of the law of parties, that happens when you and I conspire to commit a robbery. And you know that I'm going to go inside and with a gun knock off and try to steal from the clerk at the cash register. You're outside in the car. So we planned this robbery. Under the conspiracy law of parties, if I go in there and I just decide to go nuts and I go kill the clerk and you didn't plan on that happening and you didn't know that was going to happen, you can still be convicted and sentenced to death in Texas under the conspiracy law of parties, because under that provision it says that even though you did not intend to commit the act, if you should have anticipated that I would go in there and kill the clerk. Yes, it's the should have anticipated part of it. That's why I say it's real easy to say law of parties, but there's two kinds of law of parties.
So basically, if I'm driving a getaway car and the plan was you're going to go in and knock off the guard and then steal the money, then would still be capital murder. But if I'm driving the car and we didn't really plan on killing anybody, but things went wrong and they did, then I wouldn't get the death penalty.
Under this bill, you would not get capital murder. You could be found guilty of murder and sentenced to life in prison.
So is
for
it still
murder.
capital murder, just no death penalty as part of its life in prison, or is it?
Well, Representative Dutton today said something a little bit different than what's in the bill. The bill says you wouldn't be found guilty of capital murder.
You couldn't get life in prison.
But you can be found guilty of murder and get life in prison.
Okay.
Okay, thank you. I'll yield the rest of my time.
Members, any questions? Thank you. That helps.